to mitigate the cybersecurity risks that the secretary obdurately refuses to mitigate himself. That's your $3 word of the day. EAC certification requires compliance with VVSG, and VVSG requires compliance with FIPS. And so you might even say, hey, Dominion's not at fault here. Like, Dominion's like, they were fine when we gave them to you. You're the people who installed all the admin passwords. Like, your implementers have been terrible. The Republicans are appealing Judge McAfee's order in the election security case. DeKalb County Republicans now taking this up to the higher level court. We know McAfee came back down. DeKalb County Republicans filed a claim saying that Raffensperger, the Secretary of State, and the rest of Georgia election officials are doing a terrible job. We've read through the full opinion by Judge Amy Totenberg, a federal judge, who said that there have been problems here going all the way back to 2018. They have failed to rectify it. We heard some clips from the hearing that took place there in McAfee's court, where we had Peri and others come in and testify about the serious problems and how there are open passwords shared in unencrypted ways. I mean, it was just madness. And so, of course, McAfee, the same judge who said that Fannie can come into his courtroom and lie to his face, and he just sits there and takes it, is the person who said, well, you know, the government's doing a great job. There's really no problem here. And so now he's getting appealed. Now, will this get rectified before the election? Clearly not. But the appeal is still moving forward nonetheless. And so this is just the notice of appeal that has been submitted by the Republican team. And then this is the memo right now. This is their motion for interim relief right now while this is pending appeal, saying, look, a normal appellate process, especially in Georgia, takes forever. We've seen this. This is the one that we're following with the Trump case. That case is not going to be handled before the election because of the appeal. We don't even have oral arguments until after the election on that. So now the question is, can the DeKalb County Republican Party force Raffensperger and the Georgia officials to actually fix this before the election happens while the appeal is pending? So that's what this argument is. You can see Kurt Olson's on here, Harry McDonald, Todd Harding, all for the Republicans. And here is their introduction. They say, all right, listen, Court of Appeals, we are now seeking mandamus relief. Okay, we need you to tell this secretary, Raffensperger, to do the following things. He has to bring Georgia's election systems into compliance. The law says he has to do it, and he's not doing it. Mandatory requirements of certification of these machines by the U.S. Election Assistance Commission. Now, DeKalb GOP, the Republicans alleged, and they proved without contradiction, that the system used in Georgia egregiously fails to comply with these requirements, and that Raffensperger has failed and refused to take any remedies to ensure a fix. He knew of the problem since July 2021 and the non-compliance of the certification requirements since March. The machines aren't even certified, they're alleging. Now, Raffensperger argued, and the trial court held, that he had no ongoing duty, right? It's not his responsibility to ensure that the systems complied with the certification requirements when they were operating. Instead, he argued, and McAfee held, that the entirety of his obligations with regard to certification were limited to pre-purchase certifications. Once I buy them, I have no ongoing duty to continue to maintain these things. I just check it when I buy it, and then it's out of my purview. No ongoing duty arose, even in the face of overwhelming and uncontradicted proof of grave, egregious, and well-known cybersecurity risks. No, I already bought it. It's good. Now, the GOP has filed this notice of appeal, but the case has not even been docketed yet. It's going to take forever. And so due to the severity of the problem and the time-sensitive urgency of this upcoming election and the past fractious history of election disputes in Georgia, the GOP brings this motion for relief now to mitigate the cybersecurity risks that the secretary obdurately refuses to mitigate himself. That's your $3 word of the day. Now, this case involves a significant public concern and warrants the granting of relief. Now, here's the statement of the case. Republicans in Georgia say the Georgia Dominion election systems were certified by the EAC in 2019 prior to their purchase by Georgia. This federal entity said the machines are good. Now, per Georgia law, the secretary certified when they got the machines, yeah, they're good for use. His certificate said this: the Dominion voting system has been thoroughly examined and tested to be found in compliance with Georgia law, and as a result of the inspection, it's good. In my opinion, that this kind of voting system and its components can be safely used by the electors, provided, however, that I hereby reserve my opinion to re-examine this voting system and its components at any time to ensure that it continues to be one that can be safely used by voters of the state. Now, the evidence showed at this hearing with McAfee, without contradiction, they didn't even try to combat it, that the system does not, in fact, comply with federal certification requirements for cybersecurity, or that the system was safe and practicable for use. Now, the evidence showed that the systems are non-compliant in the following respects. Number one, first, the encryption keys are stored in plain text in the election database. So you just open open up a Word file or a Notepad file, and there are the keys, all the security keys right there. They still have a hard-coded vendor password that grants administrative privileges that has been publicly known since 2010 at the latest. This is the Dominion password, according to the Republicans. DVS Corp 08, exclamation point. You're going to need a special character in there. DVS Corp 08, exclamation. Wow, high security. Now, multiple users use the same usernames and passwords, so you never know who is actually accessing the system. These vulnerabilities leave the system wide open to hacking and alteration of election results without detection. Now, the evidence also showed, without contradiction, that Raffensperger has known about these vulnerabilities since 2021, and he's known of the non-compliance with the certification requirements since no later than March 24, but he's failed and refused to take any mitigating measures as is mandatory for his position. And so now we're filing for Mandamus. We want you to force them to do things. Now, here are the rules for how a Mandamus comes about, but they say this is something that we need right now. Before addressing our entitlement, let us just explain that this is available. Okay, we can get this. It's timely. The record shows that we are entitled to this relief. Now, in the prayer for relief, we requested that Raffensperger be required to order the county election superintendents to produce within 24 hours of the polls closing system logs, ballot images, and cast vote records, right? So make Raffensperger give us the numbers. In the hearing, the GOP experts recommended additional measures to include increased system logging, unique usernames and passwords so that you can measure who's actually accessing the thing, and packet capture devices to capture network traffic for analysis. And there are tests. If we apply this test to say, are we entitled to relief here? We are. They say we meet all the factors. One, we're likely to prevail in this appeal. We've met the Mandamus criteria. This is the only remedy that we can have. The only relief available in such a case would be a new election, right? Otherwise, if you don't grant this now, the election is going to be problematic. We'll have to do it again. So grant it to us now. We have a clear legal right to relief, and the trial court's one and done interpretation for McAfee is irrational. Now, Raffensperger argued, and McAfee held, that the election law requirements for certifying voting equipment as compliant, guidelines, and as safe and practical to use is a one-time inquiry. No requirement that he needs to verify that it's still in compliance after the fact. That's what McAfee said. Now, the application says that Raffensperger is, in fact, required to do more than that. He must certify the equipment as safe and practicable for use, saying the equipment shall be certified prior to purchase, and so he's in compliance with that. But he also has to ensure that the system provides all the basic functionality and the security capabilities in there. These other documents say that he's got to be in compliance, right? They're adopting, right? We're going to get into some technical stuff. Like the VVSG says you got to comply with the Federal Information Processing Standards. The FIPS 140 and 1.0 requires cryptographic keys and so on. Now, the evidence at the hearing showed that the election systems that Raffensperger is using and created do not comply with those requirements, in that the encryption keys are stored unprotected and in plain text in the election database. They're definitely not using FIPS 142 level 1 or higher that are validated cryptographic modules, right? They're just putting it in a Word doc. Can be retrieved by a straightforward SQL query by anyone, whether an insider or outsider. All you need is low-level hacking skills. With the encryption keys, any bad actor could insert, alter, or insert fraudulent election files, okay? Including ballots and results without detection. Insane. The secretary did not offer any opposing evidence and did not in any way weaken this testimony on cross-examination. So now everybody knows what the password is. Now, in addition, the evidence showed without contradiction that a hard-coded vendor administrative password had been unchanged since no later than 2010, as noted in a testing lab's deficiency report that was admitted as an exhibit. In a demonstration video, Peri, an expert, demonstrated the decryption of this password and explained that with this administration password, a bad actor could perform essentially any manipulation or alteration of the system that they might want, and they can do it undetectably because it's root access. That password, just so we're clear about it, DVSCORP08 exclamation. DVS Corp, Dominion Voting Systems Corp 08 exclamation. So Mr. Peri also showed that multiple users on systems from Appling, Bibb, Jones, and Telfair counties use the same usernames and passwords, a clear violation of password management protections that are mandated by the VVSG, which would be a subcomponent of the federal certifications. In all of these respects, the evidence showed without any contradiction whatsoever, right? They didn't come back and say, no, that's not the password. No, we do use different names. They didn't say that. They just said it's not our duty to continue to maintain it. We bought the thing and that's good. So whatever anybody wants to do with it, have fun. The system falls woefully short of the secure storage of encryption keys required by the combination of Georgia law that requires EAC certification. EAC certification requires compliance with VVSG, and VVSG requires compliance with FIPS, which is meaning you actually have to have security. And FIPS requires the secure storage of encryption keys. Now, moreover, this vulnerability fails the requirement that Georgia's election systems also be safe and practicable for use. So it's violating that law too. Now, Clay Peri described the storage of these encryption keys as egregious. He further explained, he says, there is no security, all right? For what little that you claim as security is irrelevant. What's more important than security is the integrity of the system. And guess what? There is no integrity, because you have to understand that these keys are vital to the security and the integrity of the system. This is how you validate it is secure and that it cannot be tampered with. Another expert came out and said, if I'm looking at cybersecurity of the encryption keys from a hacker's point of view, hallelujah. If I'm looking at it from a cybersecurity perspective, I can't believe that anybody would ever do this. You know, if you're talking about the criticality of ensuring the integrity of the vote, which is the base for our democracy, then how could you ever leave this unprotected? So I find it frankly appalling, as every American should feel. Now, Mr. Cotton drew an analogy to a bank vault. He said, if you've got a bank vault and that's the latest and greatest lock on the bank vault and you tout that security on the bank vault, what you've done here is the equivalent of writing in big bold letters the combination of the wall next to the lock, okay? So there really is no security if you can get access, either remotely or physical access to those systems. Now, the application and the evidence at the hearing also showed that in the long-running Raffensperger litigation with Curling, before Judge Amy Totenberg, that we talk about all the time here, plaintiff's expert Alex Halderman had prepared a sealed expert report, later unsealed, that was delivered to Raffensperger attorneys at the time that noted the encryption keys were stored in plain text in the election database. They knew this all the way back in 2018, and it could be retrieved with a simple prompt. Halderman reached the same alarming conclusions regarding the insecure storage of the election keys as Raffensperger. The trial court's holding that there was no ongoing requirement to comply with EAC with respect to cybersecurity renders the certification requirement an empty gesture and nullifies the obviously intended requirement that the system meet security standards and not merely are fine in a testing lab until somebody brings them back to the state and then rigs them. The trial court's holding cannot be reconciled with the plain language of the rules, which requires ongoing compliance. The VVFSG says there has to be continuous confirmation that a voting system conforms with the guidelines, and it has to continue throughout the maintenance life cycle of the voting system. And so in sum, our evidence was overwhelming, and it was uncontradicted that the system in Georgia does not even come close to complying with the standards for EAC certification or the requirements of Georgia law. They're not safe and practicable to use. Here, the evil is an election system that is unprotected from cyber threats, and the remedy is a system that complies with the requirements. It defies common sense to conclude that a requirement for a system to be certified as secure and safe and practicable for use does not require that it's actually secure in use. Now, the trial court applied the absurdity doctrine articulated by Antonin Scalia in his treatise. Now, it has been cited from time to time. It's not how we do things in Georgia. It was in a treatise, right? It was in Justice Scalia's article, not in a Supreme Court opinion. The court explained in the Georgia version of this absurdity doctrine, and so the court is reading something that doesn't even apply here. Here, the method of construction mandated by the Georgia legislature supports our request for mandamus. And so we need to restore confidence in this. The machines need to be certified by the Secretary of State as being safe. Raffensperger's lawyer said that, well, they cited this as support for their interpretation of cybersecurity. But the article even goes against them. They say cybersecurity was at the forefront of both legislative and judicial attention. Now, Totenberg, the judge, in a different opinion, in the Curling litigation, was on the verge of ordering the state to replace the Diebold DRE system, and she eventually did it. So then Secretary of State Kemp formed the Secure, Accessible, and Fair Elections, the SAFE Commission, to recommend a replacement. The first word of Raffensperger's new plan is secure, safe, secure. They emphasize cybersecurity all the time. Everyone knows it's important. Despite them saying it's important, despite them creating new systems that are secure, they don't care. Despite the crystal clarity of the importance of this, the trial court through McAfee held there was no duty to ensure operational compliance with certification at all. The judge ruled that the secretary doesn't have to keep the machines certified in Georgia. This may be analogized to holding that even if the secretary has actual knowledge that his submarine has a screen door instead of a watertight hatch, his pre-purchase certification of the vessel as a seaworthy vessel relieves him of any other further responsibility for the safety of the ship or the crew. They said it was great, so that's all I need to do. Now, by the trial court's reasoning, even if the secretary had actual knowledge that the Dominion machines switched half the votes from Democrats to Republicans, he would have no duty to remedy the problem, right? That's what the judge held. No, he certified they're fine. Okay, but now they flip every other vote. That's okay. He checked them at the beginning. Compounding the incongruity of McAfee's pathetic holding, the contract for the purchase of the Dominion systems emphatically and unambiguously requires continuing compliance with all certifications. It requires the systems meet all mandatory requirements and accurately function in accordance with those requirements, enabling the state and others to accurately administer their elections. All of Dominion's security protocols are designed and implemented to stay current. And so you might even say, hey, Dominion's not at fault here. Like, Dominion's like, they were fine when we gave them to you. You're the people who installed all the admin passwords. Like, your implementers have been terrible. Data generated by the Democracy Suite platform is protected by the deployment of FIPS, and the contract requires the vendor to carry out periodic security assessments to ensure the contractor's continued compliance with their obligations as they relate to data security. And they're not doing that. So we're confronted now with the spectacle of Raffensperger disclaiming any ongoing responsibility to make these systems secure. He tells the public, he goes out in his stupid speeches and says, we take every measure possible to ensure the integrity, security, and fairness of our elections. But you don't. Everyone has the same password. The court, finding no ambiguity in that, also failed to consider things when viewed in full context. Their interpretation of the statute produces a result that cannot be squared with any rational legislative purpose. Saying the secretary has no operational compliance obligation is flagrantly unsafe. Whatever the jurisprudential merits of the textualism may be judged, however you're interpreting this and reading this, this is lunacy. It's nonsensical. The one and done interpretation is inconsistent with Georgia law. Georgia law says safe, consistent with their authority. These should be safe. Now, in this litigation, the GOP proved without any contradiction that Dominion systems in Georgia have grave vulnerabilities. They do not comply with certification requirements. The secretary moved to dismiss, arguing without any citation that the GOP has raised tired old claims that have been previously asserted and adjudicated. And DeKalb and the GOP and their sworn testimony from the secretary's general counsel, right? Sworn testimony from Raffensperger's general counsel that the encryption key and the certification issues in this case were a new allegation that was made for the first time in a court filing, which was August 2024, and explaining that those allegations were not made in 2020. They're different allegations. But even assuming that that is defensible, saying that they are not the same problems, that indifference became indefensible after the evidence was presented, showing the system's vulnerabilities, and the secretary's counsel's sworn testimony showing that the initial position was wrong, right? He said one thing and it was proven wrong. We are well past the point of willful ignorance, okay? They can't sit here and just say, we didn't know any better. Now it's an abuse of discretion. They know about it. They're not doing anything about it. Now they're responsible for a continuing program to run our elections. Now they know these flaws exist. They should have a continuing duty to prevent those. Continuing means continuing. And if he can't fix it, then he should educate election officials about the problems so that these known security flaws are mitigated and the election is not compromised. And if you don't grant relief, we're going to suffer irreparable harm. Obviously, the public interest favors a stay. The reason we have elections is so we have legitimate outcomes. And so here's what they want. They want Raffensperger to order county election superintendents to use unique usernames and passwords. They want to order county election superintendents to set system and database logging settings to capture all the events. Order superintendents to produce public systems after 24 hours after the polls close, within 24 hours. Also to produce ballot images within 24 hours after the polls close, which would be great so that we don't see all of the additional ballots coming in from their wheelbarrows. Now, order county election superintendents to also produce these records by the close of the polls. The court should enter an injunction pending appeal to require the relief that we are demanding, signed by RNC, GOP, Georgia attorneys, Peri, McDougal, Todd Harding, and Kurt Olson on behalf of the DeKalb County Republican Party.